Well, hello there. How is everyone? I hope you're all well. You're amazing, amazing, beautiful, wonderful people. You're looking absolutely amazing on this thirsty Thursday. I'm going to get straight into the meat and potatoes. This is video 2 of 2. Earlier on, we spoke about the video that was sent to me that pulled me out of having a day off. That was Brian Enton talking about Bryan Kohberger, who's apparently complaining about basically being tortured, sleep deprivation in incarceration. And yeah, there's some thoughts and feelings around that. So if you missed that, go check it out after this one, of course. But in this video, I just want to go through, someone reached out, Susan, and she sent me, so you probably won't be able to read that, but I need it so I can read it. So I can read it. I've got my glasses on so I can see it properly today. Some information on potential violations that were seen in the Idaho 4 case. And as we sit there and we think, is Bryan Kohberger going to appeal? Is he not going to appeal? What are the likelihood of him appealing? Is it possible? Let's just go through some of these. This is someone who is knowledgeable about the law in the US. And let's just go through some of the things what she has raised and whereabouts we saw them. So she talks about due process violations, 5th and 14th Amendments, denial of fair trial, which I think would be fair to say that it was denied. Ultimately, Ann Taylor had turned around and said, I'm not ready. I'm not ready to go to trial. And Judge Hippler might as well said, well, tough shit. So if you're put in a position where you're not prepared, you could argue that is denial of a fair trial. We know that there was bias in the community. We know that the reporting was biased, and the overall feeling towards Bryan Kohberger was one of he shouldn't really be going to trial. It's a done deal, which is the next point. Pre-trial publicity and juror bias, extreme media saturation in Idaho and Washington, gag orders limiting defense ability to counteract public narrative, prosecutorial misconduct. Prosecutorial misconduct is a hard one to prove in some circumstances, but what we do know is that there was a leak. There were leaks all the way through this, and it would appear that you're either talking about, in my opinion, law enforcement being involved in the leaks, and potentially Cellbrite as well, who seem to have dropped themselves in the shit by some of the things that they were saying, and you pair that with some of the stuff that is out in the media. You're now looking at alleged Brady violations, failure to disclose exculpatory evidence, e.g. cell phone tower data, possible alibi, which we're still waiting to hear from Ray, who is currently off grid. Someone needs to use his technology to find him. Some people have said that he is still under gag as Judge Hippler makes his way through documentation. So as soon as he's gone through all of the bits that include Ray's testimony, Ray should be able to speak. Others are arguing that no, Ray isn't under gag order and he does have the ability to speak. I'm just waiting on tenterhooks as to what he has to say. Statements to media that may have prejudiced the case or tainted the jury pool. Judicial bias or prejudicial rulings, which I think that anybody with half a brain cell would be able to admit that there was judicial bias and prejudicial rulings. Some of us argued that, especially Hippler, he seemed to be a fifth wheel for the prosecution, and that absolutely shouldn't have been the case. You've literally got the likes of Cellbrite, for instance, they're literally contradicting what the lead prosecutor is saying, and they were going to be at trial saying what they were going to say. And then you've got Ray, another specialist in the cellular industry of over 2 decades, and he is called, in court, a conspiracy theorist. There you go. Court rulings denying key defence's motions that may have prejudiced the defendant's ability to present a full defense. Again, we saw this. There was constantly motions that were being denied by Hippler. Some people will say that was right for them to be denied. Others would argue. and also concerns over the judge's handling of the gag order and evidence rulings. The funny thing is, we saw initially Hitler, one of the first things he did was to question why so many things were being gagged when they could have just been redacted. He then went in and released a load of documents, but then within literally a few days, we saw it go back to task. As it was almost as if Hitler came in thinking he was going to be able to change things, but very swiftly someone put him in line. That's how it looked. That's just how it looked. I'm not saying that's how it is. That's just how it looked, because we did very quickly see just pretty much every single document going back to being, again, gagged and blocked. Fourth Amendment violations: unlawful search and seizure. Questionable basis for the probable cause affidavit used to obtain warrants for Kohberger's phone, vehicle, DNA, and apartment. Use of genetic genealogy to target Kohberger may violate Fourth Amendment rights if warrantless or overly broad. Multi-jurisdictional warrant execution issues: Pennsylvania, Idaho, and federal agencies. Normally, Fourth Amendment claims are not reviewable in federal habeas unless the state failed to provide an opportunity for full and fair litigation of the claim. Stone versus Powell. Now, I'd like to see what some people comment in the comments regarding this issue, because I think we do have some issues surrounding the DNA, the IgG specifically, and it could be argued that some of the earlier things, if you look at the probable cause affidavit, for instance, did at the time the PCA was put together, was there enough evidence to warrant what they did? That's the question, because it almost looks like this case had to be reverse engineered, and if this would have gone to a preliminary hearing, I don't think it would have been upheld in court. I think they'd have probably bounced out. We certainly heard from the grand jury, if Jay Logston's points were right, in that even the grand jury didn't really feel that there was enough there, but there was enough to do what needed to be done. And we also know that from an exculpatory evidence perspective, it was argued that Bethany Funk potentially had exculpatory evidence and was being blocked. And for her not to also turn up at sentencing and not to be involved in any degree of fundraising that you've seen her counterpart do, it does raise questions as to why is Bethany Funk seemingly the odd one out. She sticks out like a sore thumb. But there we go. Sixth Amendment violations: right to counsel. If Kohberger's team was denied access to critical discovery or prevented from fully participating in pre-trial proceedings. Right to a speedy trial. Extended delays, some arguably caused by the state, could be construed as a violation. Right to a public trial. Excessive sealing of records or closed proceedings may violate openness requirements and confrontation clause. Again, the speedy trial issue, people are going to say in hindsight, should he have just gone to trial in the first place? But hindsight's a fine thing. And the thing is as well, is I think that people are going to look at this in a different context now that he has pled guilty to the crime. What we must understand is that if you've got a gun held to your head, you'll be surprised what you'll admit to doing. And what with his behaviour in court, he seemed to be relatively respectful. You didn't really see anything that was indicative of him being a monster. Which, if he'd done this crime, he is a fucking psychopath. He's an absolute fucking psychopath. And now he's in prison and in jail, moaning that people are shouting at him through the vents. Again, it's an odd one. It's an odd one. But Eighth Amendment: excessive bail or pre-trial punishment. If conditions of incarceration before trial were unduly harsh or intended to coerce a plea. Cruel and unusual punishment. If he's subjected to isolation, harassment, or deprived of necessary medical mental care in custody, which you could argue that is exactly what is happening now. He is seemingly suffering from Eighth Amendment constitutional right violations, but some people turn around and say, well, now he's in incarceration because he's admitted to committing this crime, and the constitutional rights don't apply to him. He's fuck him. But it'd be interesting to hear your thoughts down below based on that. Excessive bail, pre-trial punishment. We don't know what his conditions were leading up to what would have been the trial. It sounded like his dietary requirements were being cared for. He always looked okay when he went into the court hearings. When you look at Richard Allen, fuck me, Richard Allen looked like I don't know, he'd look like the poster child of don't do meth by the time they'd finished with him. But then we got 14th Amendment, equal protection, substantive due process, targeting based on profiling. If Kohberger was selected via genetic genealogy without sufficient judicial oversight, the argument could be made that this targeted an arbitrary class or relied on unconstitutional surveillance methods. State misconduct in charging filing, if charges were brought in haste or without the opportunity to fully review countervailing evidence. Was this a case of biasness? We've seen it before. We've seen it in cases. Was this reverse engineered? Did someone point the finger at Bryan Kohberger and they built the case around him? Again, I understand that we're in a different position now because Bryan Kohberger has pleaded guilty to this crime. So it does kind of make you think, well, this is kind of like closing the stable door after the horse has bolted. But you still have to consider, did Bryan Kohberger, commit the crime, or did he plead guilty because he had no other option but to plead guilty? And was there indeed some form of legal strategy involved? Who knows? It's a toss of a coin. And the last one is cumulative error doctrine, which is even if no single error justifies relief, Kohberger could argue that the totality of procedural and constitutional errors resulted in a fundamentally unfair proceeding. So they're saying if you can't just take one of these elements on its own and say that is enough, could you say that taking different elements, different aspects of what he went through and what happened, the totality it's the same as when you look at the evidence, circumstantial evidence. This is no different, isn't it? Circumstantial evidence, if you look at them on their own merit, they don't appear to be that strong, such as a white car that could be an Elantra, it might not be Elantra. But then you think, well, also he drives a white Elantra, okay. And then you look at the phone potentially being switched off, unless you believe Selbright, and then it definitely was switched off. But then Bill Thompson would seemingly suggest that it might have been switched off, looked like it was. But again, when these things, the purchase of a knife on Amazon, they do start to move the needle. But what I will say is whether someone's innocent or guilty, they do still deserve the right for the process to operate correctly. And that's where we go down the route of, do the ends justify the means? Are people happy regardless of whether he's innocent or guilty because they got the outcome that people wanted? But are there anybody out there that feels, hold on a second, regardless of his innocence or guilt, did the process operate right? Was it above board and correct? Because if it wasn't, then you've got a system that has the ability to take people's freedoms away and technically not work as it should. And in that situation, it could lead to people being wrongfully incarcerated. And has that happened before? Fuck yes, it has. People have lost decades of their lives. People have lost their actual lives wrongfully. And this is how it starts. This is how it happens. The violations of constitutional rights and people being okay with it happening and turn the blind eye to it. Let me know how you feel down below. Let me know. and I will catch you all tomorrow live. I was going to go live tonight. I'm not now because this was going to be my day off. I'm going to go live tomorrow. So keep your eyes peeled, and I will see you all then. Love you all. Mwah.